Okay.
This is Ron Nowell from the Woke York Historical and Cultural Association right here. And if you'd like to be a member, you can call Kevin Freeman. He can tell you all the rigorous requirements, which are none, to be a member. And our goal is to reawaken people in York to your past history. I feel right at home here now. I'm standing on the site of the first public bathhouse on Long Beach that my father built, and my mother was chagrined that he was connected with it, so she referred to it as the Castle by the Sea. So our family and a lot of people in York Beach have picked that up, and they now refer to it as the Castle by the Sea. Although I noticed that Mike Sullivan never put that name on the building. We're down here to discuss the historical background of what I call the People's Beach. Call it the People's Beach because it's always been owned by the people. The people gained ownership on November 2nd, 1652, when York was chartered a municipality by the Commonwealth of Massachusetts legislature. The town of York has always held title to the beach and the seawall until the formation of the York Beach Village Corporation, in which the title passed to them. 1978, when the beach was dissolved in a private and special law, then the title went back to the town. So the town has always held the title. The only time that I know of that the title passed from the town was when the York Beach Village Corporation was extended in 1917 or 1921 from the Cutty Sark down to Long Sands Road. And then the title to Long Sands went to York Beach because the enabling legislation said that all land titles within York Beach held by the town of York would go to the beach. It stayed with the beach until 1978, when York Beach Village Corporation was dissolved by another special and private law, and then the title went back to the town. So when I heard the town was buying it, our group was interested in what the town's title chain would say, because we were interested about, now I wonder who they think they're getting the title from. So when I went and asked for the title chain, I found out that there was none. And I thought, that's strange, because nobody in York would buy a smelt shanty without a title chain. And I can't believe you spend $4.6 million on a piece of land with no title chain. So I got the documents provided by the town manager of the so-called title chain. And it said it's based upon a real estate concept that if you register a deed for 40 years and nobody challenges it, you can convey it. And that's not I can't believe it. I've asked 6 real estate agents in York about that, and they have never ever heard of such a thing. So I did what Robert Magosi told me to do years and years ago, and Robert Magosi did it all the time. Robert Magosi was the best title researcher. As Robert did when he researched a large piece of land, he went back to the original grant. So taking James Kent's town grantor index up until 1727, we went back to the original grants. All of the original grants, from Libby's campground to the Cutty Sark, when the land was granted, on the seaward side, it says to the fresh water at the base of the seawall. As far as I know, the fresh water is on the landward side of the seawall, and it's salt water on the side that I'm standing now. Every grant along the beach only went to the fresh water. The town kept title to the seawall and to the beach for the use of the people. They used it for sand to fill in. It was cheap and easy to get. That's why Harry Norton could sell swamp lots in the back of the seawall, is people could go to the seawall and drag the sand out into the swamp so they could build a house. 90% of the first summer houses built on Long Beach, the front of the house set on reclaimed land from the seawall, and the back of the house set on wooden pilings in the freshwater swamp. So you want to say, how did Harry Norton get a title to it? Well, that's a real interesting story. Jerry was on the Board of Overseers with Harry. He was a contemporary of Harry. He was a business associate of Harry. He was a good friend of Harry, and he knew Harry really well. And one thing you can say about Harry Norton and his son, Roger Norton, is they were extremely principled. They believed in the principle of something, not the value or not what anybody would assign any cultural intrinsic assets to. They were always about the principle. So much so that citizens in New York referred to Harry and Roger as the Sue brothers, even though they were father and son. That's S-U-E, because they were involved in so many suits based upon principles. So 1932, I believe it was, the town of York wanted to adopt an ordinance to prohibit people from taking sand from the seawall because the road was starting to collapse because people were taking so much sand. Well, Harry didn't want that to happen because that's how he could sell the swamp lots, because they accessed the cobble and the sea sand. So the first thing he did was he ran for selectman. He got elected selectman, and he couldn't get him to stop that process. So he ran for overseer in York Beach. So now he's the first person being a selectman and overseer at the same time. After he got elected overseer, he tried to convince the other overseers, look, we have to sue the town because we own the beach, because we got the title to the beach from the town when we were formed. It's right in the legislation. Well, he couldn't convince the overseers to sue the town, so he didn't want to sue the town because of the expenses and stuff. So he says, well, you know what? The Dunnells sold all of the other end of Long Beach, Samuel Dunnell and his heirs. Samuel Dunnell and his heirs sold land all along this side of Long Beach. So if anybody owned it, it's probably Samuel Dunnell heirs. So we tried to figure out who alive could be a Samuel Dunnell heirs, and he settled on this woman, Hattie Littlefield, which I guess was a great-granddaughter of either the second or the third Samuel Dunnell. He sued her, and I don't know why, and we don't know why. He ended up getting a judgment of $260 against her, and he took it in 2 quitclaim deeds to Long Beach, from the Cutty Sack to Ray Saul's store, and from Ray Saul's store down to Elm Point in 2 deeds. Now, I don't know whether the woman ever knew she owned it or knew anything about it or whatever, but Harry assumed she owned it. Well, Jerry knew that, one, she didn't own it, that they owned it, and he said, we never paid no attention to the deed. So in 1956, the corporation votes to build a restroom on Long Beach. So they hired my father to build it. So we came down here and we set up a transit and stuff. We hadn't been here 5 minutes. And the guy from right across the street that owned the convenience store, and I think his last name was Davis, I can't be sure, came running across the road. What are you doing? I said, well, they're proposing to do a restroom here. And he goes, no, 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 I own it. Get out of here, get out of here. I'm going to call the cops, get out of here. So he couldn't call the cops because there's only one cop. And that was old Arthur Perkins. So he goes, I'm going to sue all of you. So he sued the York Beach Village Corporation. So Harry Norton's son, Roger, and I think he was an overseer at the time, said, well, I own it. So the court suit was whether or not whether Roger owned it, but whether or not the guy across the street owned it. Okay? And the court ruled that the guy across the street did not own it, that nobody across the street owns it. So there was never any court case that said Roger owned it. So if the corporation knew that Roger really didn't own it, why did they buy it from him? They bought it from him because Roger says, if you don't, I will sue you. And Myron Russ was their lawyer. And Myron says, you know, I've had experience with Roger, we all have, and we know that based upon principle, he will go all the way to the Maine Judicial Law Court. And he said, that's going to cost a big sum of money. So give him his $150 that he wants for the land, and it's all done with. So it was cheaper to get a nonsensical deed than it was to go to court. So that's why they paid Roger for the land. Now, prior to all of this, 1923, Brigadier General Billy Mitchell landed a bomber on Long Beach to prove that the beaches here could be used as emergency airfields in a time of war. And by landing on Long Beach, that was one of the charges against Billy Mitchell when he was court-martialed, was he didn't have the government approval. So in 1938, the Postal Service said, you know, Mitchell was able to do that. Let's start a aerial mail service. We'll land on Hampton Beach. We'll land at Long Sands, Wells Moody, Kennebunk, Old Orchard. So they landed on the beach here in 38. There's a picture in one of John Bidwell's books of people crowded around the plane, right exactly where we were standing. The plane was parked. And Tom Anderson's father, Tom Anderson, lived beyond Elm Point on land that was original Samuel Donald Grant, where everybody down there claims they own to the low water. Tom's father had formed an association down there called the Long Sands Improvement Association or Society. So he notified the Postal Service, I own that beach, I'm going to sue you. So we don't know, John Bidwell and I talked about this ad nauseum. And we never knew whether Anderson actually sued the post office or not. But the final settlement was the federal government said the beach is public property. So you don't have any say. Now, we never knew whether or not that was a judgment on all the beaches, which we thought it was, because why would they just say Long Sands and not Wells, Moody, Kennebunk, Old Orchard? So that's something that those people that are fighting that don't realize about that federal government, and that came from the Attorney General, that ruling. So when we went back and we looked at the original grants, it all says to the fresh water at the rear of the seawall. So much to my surprise, last Sunday when I picked up the Sunday Telegram, Portland, There's an op-ed opinion in there by Professor Orlando DeLugo from the University of Maine Law School, and I hope I pronounced his last name right. And in it, he gave 7 legal reasoning why no private property owner owns to the low water mark in Maine. And as he points out, there's no municipality, coastal municipality, that ever gave any private property rights to the intertidal zone. He gives 7 legal reasons why. So right now we got the other end of Long Beach, everybody owns to the low water mark. No, they don't. Those are all bogus. Over on the shore path, all those people own to the low water mark. No, they don't. Up York River, some people's deeds say they own to the middle of the river at low tide. No, they don't. If you go back and look at the original grants and then follow it down as it's conveyed up into modern time, you will find out that the lawyers have changed the descriptions in the deeds to lessen public property rights on private property and to increase private rights on public property. And it's well known and it's well documented. And that's what's happened to that end of the beach down there. Nobody down there owns onto that beach. That's all bogus. And it's the same thing about Harry Norton's deed here. It's all bogus. Now, Harry was an extremely honest person, and he made an honest attempt to figure out who owned us because he thought somebody may. But the assumption that somebody may was wrong. So there was nothing dishonest or anything else about the Nortons getting title. It was an honest attempt to stop the town from stopping people from removing sand because it would damage his real estate sale. That's all. And it's just incredible. So I gave all this information to the chairman of the board and to the town manager, and as far as I know, none of this has been passed on to the town attorney. None of it. So what I call this is the second major multi-million-dollar boondoggle by the current chairman and vice chairman of the Board of Selectmen. They are 2 of the 4 people that were responsible for the public safety debacle down on Ridge Road to the tune of $3 to $4 million, but we, the public, will never know what it costs because they refuse to have a forensic accounting of that. So we'll never know, but it's between 3 and 4 million. And now they've blown another 4.6 million on something that we already own. But luckily, it says in the title that if we later find out that the Nortons didn't own it, we can get our money back. The only way this can be settled is a town lawyer has to do a grantor index for the town of York from 1727 till now, because we have only done it till 1727 using James Kinster's Town of York Grantor Index. We need to finish it. For 35 years on Board of Selectmen, I tried to get the town manager to put in the budget to fund the lawyer to do a town grantor index. They would never do it, and here's a $4.6 million reason why they should have done it, because they would have known we already own it.